Hear ye. Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, this honorable court, this great state of Florida. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Our case today is number 22735, Allstate Insurance Company versus Rebuttal Chiropractic. Whenever you're ready.
Good morning, and may it please the court. My name is Rick Godfrey. I represent Allstate. As the court knows, we are here on a certified question from the 11th Federal Circuit Court of Appeals. You're familiar, I know, with the certified question as phrased and Allstate's alternative phrasing.
Counsel, I'm sorry. I'm having a little trouble hearing you. If you could speak up a little bit.
Absolutely. I apologize, Your Honor.
I think it's more my ears than your projection.
I'm not often accused of being soft-spoken, so I'll try my best. As you all know, the certified question from the 11th Circuit and the modified certified question that we posed, but in preparing for this morning's argument, it occurred to me that there's another way of thinking about this. It's to ask a very simple question, but that is the jugular issue. Where in the PIP statute does it mandate an insurance company to pay 100% of a provider's medical bills? The overarching statutory mandate is to pay 80% of reasonable medical charges. There are no exceptions to that, with the narrow exception that the insurance company may, if it so chooses, pay 100% of a billed amount that is less than the fee schedules. And that is the guts of this case. Now, we submit that this court, although not directly on point, in its principal ruling in MRI Associates, answered the question. The court in MRI Associates issued 4 holdings that fundamentally disagree with what the Revival Federal District Court held. Holding number 1, this court rejected the notion that there are 2 mutually exclusive payment methodologies. It just rejected it. That's not what the statute says, and the court rejected it. Second, this court reaffirmed that the overarching statutory mandate is 80% payment. That's what the statute says. It's plain, clear, unambiguous. Third, this court held that, quote, a reasonable reading of the statutory text requires that reimbursement limitations based on the schedule of maximum charges be understood, as State Farm contends, simply as an optional method of capping reimbursements rather than an exclusive method for determining reimbursement rates. By its very nature, a limitation based on a schedule of maximum charges establishes a ceiling but not a floor, end quote. And that's at page 584 and 585 of the court's opinion. Revival holds, in effect, just the opposite in the Federal District Court. Now, in fairness to the Federal District Court judge, that judge did not have the benefit of this court's opinion. But the court misread the statute we submit regardless of this court's opinion.
Counsel, could I focus on 2 words in the excerpt you just read? They are the words optional cap,
Yes.
which seems like a very odd construction indeed. I guess one core question I have for you is, when would an insurer ever opt to allow a 100% of the capped fee when an 80% cap, an 80% payment is consistent with the statute? Isn't that a troubling consequence of how you're asking us to read the statute?
Not at all, and there's 3 answers to that, which we covered in our briefing. One is that was a legislative determination of policy. Number 2, I could postulate any number of economic reasons why an insurer would do that. Let's say that the medical provider is the lowest cost provider by a substantial margin in a particular geographic area. I would want to encourage others to reduce their fees to match the reasonableness of that medical provider's fees, and so therefore I pay 100% to encourage that. And so we articulate those reasons, but fundamentally, that is not I think, we submit a judicial issue. That's a policy decision. Years ago, I represented a large petroleum company where they went in for something called discount for cash. They would charge less for gasoline if you paid cash, and people thought, why would you do that? It's counterintuitive, because they had done studies that they gained market share, and not small amounts of market share, and so they ended up making more money by doing that. It was counterintuitive, and people sued over it. The cases uniformly came out in favor of the petroleum company, but we had the same gut question, which is, why would a company or why would an industry do something like that? And it changed the industry. So the answer is, I don't know whether insurance companies have done those studies. I simply know what the possibilities are, and I know that the record here reflects that this was not a judicial decision. This was a policy decision that was made by the legislature. But regardless, even if the legislature made a mistake, when you look at the language, it goes back to the jugular question. Where does it say you're going to pay 100% mandatorily? The word may was an intentional choice. That's permissive. They could have said must pay, could have said shall pay, but they didn't. They said may. And that, I think, answers the question. At least I hope it answers the question. So MRI Associates, we think, as a principal matter, addresses what's wrong with the Federal District Court's opinion of revival. And again, in fairness to that court, it did not have the benefit of this court's wisdom. But when you look at it, setting aside MRI Associates, the Federal District Court made 4 fundamental errors of law that are somewhat inexplicable. And what it did was it rewrote the statute. We all know, and this court has held repeatedly, that it is not the province of the judiciary to rewrite the statutes. We may think a statute doesn't make a lot of sense, but it's not the province of the judiciary to rewrite it unless it has constitutional implications. So what were the rewritten parts? Well, number one, they eliminated the overarching 80% payment obligation. You now have a 100% payment obligation. Number two, it rewrote the statute to mandate 100% of payments. The statute could have said that. I could see a statutory decision to make that decision, make that judgment, but the legislature didn't do that. 3, and this is contrary to virtual imaging and other cases that this court has decided, it rewrote the PIP statute to redefine the word may into must or shall. You can't read that section of the statute with the word may and come up with a conclusion that means must or shall. And then 4, it rewrote the PIP statute to prohibit insurance companies from having notice or policy language that medical bills in the amount less than the fee schedule amount will be paid at 80%. Now, what the Federal District Court did was it recognized that Allstate's policy expressly provided that for a billed amount less than the fee schedule amount, Allstate could pay at 80%.
Counsel, I think we agree that it doesn't say pay 80% of the billed amount. It says pay 80% of reasonable medical expenses. And then it essentially gives 2 specific ways to determine that. One is very fact-specific. It gives a series of considerations. The insurance company can review those considerations to determine reasonable medical expenses. Or it gives this sort of bright line rule. Allstate's policy gives instead 2 bright line rules. It doesn't have you do any sort of analysis of reasonable medical expenses. It simply says 80% of the cap or 80% of what is billed if it's less than that. How would you describe that sort of discrepancy between the 2 approaches?
I think 2 responses, Your Honor. First, the predicate of your question, as I understand it, assumes a binary exclusive choice methodology, fact-dependent or fee schedule dependent.
No, it could be both.
But, of course, we know from MRI Associates that you can have hybrid model or alternative payment methodologies. Secondly, one of the cases we cited from the lower courts actually phrased it better than any of the appellate courts, and I'll read that. It's in the record. It's the Miami Medical Group case versus Auto Club. And I think it directly answers Your Honor's question. It says, quote, if a medical provider is prohibited by Florida statute section 627, 736A5 from charging the insured or insurer more than a reasonable charge, then an insurer is never statutorily obligated to pay more than 80% of the billed amount. Any other interpretation would be irreconcilable with Florida statute section 627, 736, etc. Here, the medical provider chose to bill it. Allstate assumed that's a reasonable amount. It's less than the fee schedule. It has a provision in its contract, a notice very clearly stated, that says they'll pay 80% of the billed amount. Otherwise, if you assume the reading that there's only these two choices or some mixed bag, but Allstate can't do that, then it has to pay 100%. And I go back to my jugular question. When you strip away the two versions of the certified question, where in the statute is there an exception that says an insurance company must pay 100%? Now, given the centrality of the importance, and this court has said it's the heart of the statute, the 80-20 split, that's what this court has said repeatedly. Given the centrality of the 80-20 split, one would think that somewhere in the legislative history, somewhere a court would say, oh, there's a mandatory 100% payment. And that has not been done except for the 3 appellate decisions, and those appellate decisions have the problems we've identified in our briefs. Number one, they're based on the GEICO policy language. And interestingly, Judge Bloom of the Southern... Yes.
The GEICO, they're dealing with the GEICO policy, but in a certain way they seem to be detached from the language. I mean, they cite it, but they don't really seem to focus on that language. I mean, am I wrong in understanding that? I mean, I'm not...
No, you're 100% correct. Judge Bloom of the Southern District of Florida, a case called Gerber 1, she never reached the statutory interpretation question because she had the same GEICO language. She said, look, the contract to GEICO required them to pay 100%. There's no statutory interpretation. I don't know what, she didn't quite say it this way. She was very polite, but she basically said, I don't know why people reach the statute. The contract is the contract. So you're correct. So one problem is it's the GEICO language that they seem to be detached from. The second problem is that they misread the statute. I mean, let's face it, the Progressive versus Back on Track case versus the other 3 cases, Irizarry, Wicks / Hands-On, and Moransky are irreconcilable. But what Progressive points out is it can't understand why none of those 3 appellate court cases starts with the overarching mandate of paying 80%. I mean, it not only makes Your Honor's point, but it makes the point that they seem divorced from the language of the statute, and it goes through that. Obviously, we agree with the Progressive decision. One of the key issues, though, in defense that Revival raised, and it's important to make this observation, is that throughout their brief, they revert to a contract language argument where they say that Allstate exclusively, so word they use, chose the fee schedule. They say this something like 30 times. And the district court said that. The federal district court said that. It's difficult to understand because this is based on a factual stipulation, which is docket entry 26, pages 2 and 3, and it doesn't say that. It says the opposite. And we quoted in our brief where Allstate specifically says that if a billed amount is less than the fee schedule amount, it'll pay 80% of it. So the fallback position that Revival has based on a contract that Allstate agreed to this, there's not much I can say other than the stipulation speaks for itself. It's plain, unambiguous, and it says just the contrary. Now, how the federal district court got that so wrong, I don't understand. I've seen this once or twice before where that's happened, but that's their fallback position. So when you come down to it, you then end up, what's the statutory purpose here? The statutory purpose is to benefit insureds, not providers, not insurance companies. And here, Revival argues, well, we're eliminating copay. Well, that's contrary to the statutory purpose, and federal studies, which we cited in our brief, have pointed out that actually harms insurers because it results ultimately in increased premiums. And that's also consistent with the legislative history of the Florida legislature when it adopted the statute. So we know that what's happening here is the Revival insureds did not make the copay payment. They never collected from them. Revival says we are eliminating the copay, which is contrary to the statutory mandate, contrary to the legislative purpose, and in the end will increase premiums and decrease benefits for insureds, contrary to the very purposes of the statute. And Revival's response is, well, legislative purpose is unimportant and irrelevant because we go with statutory text. But of course, our position is the statutory text is crystal clear, and does not support the arguments accepted by the federal district court in the revival opinion. So in sum, MRI Associates, we believe, is incompatible with the decision of the federal district court. Even if MRI Associates had not been decided, the federal district court's decision is predicated upon 4 errors of law in which the court rewrote the PIP statute. And in the end, the rewriting of the PIP statute does benefit one group at the expense of 2 others. It benefits medical providers at the expense of insureds, and secondarily at the expense of Allstate, because Allstate, in this policy, had a specific provision defining exactly how it would pay, when it would pay, and under what circumstances it would pay. But all of that has been eliminated and voided. I have 5 minutes and 34 seconds left. I've reserved 5 minutes, so unless the court has any questions.
Can you, let's assume that there's a contract, not like this contract, but where the insurance company says, clearly, we're only gonna, choose the path of the fee schedule approach. We're not going to try to do a hybrid or anything
Like the
that.
Geico policy?
Yeah. So what work is the May doing then in the May pay? Like, why would the legislature need to give them permission to pay 100% if it's
Sure. The fundamental answer, simple answer to that is you have an overarching statutory mandate to pay only 80%. And so if you're going to pay something higher than 80%, you would need to have an exception carved out. And the question then becomes, is it a mandatory exception or a permissive exception? And in this case, the legislature, for good policy reasons, chose it to be a permissive exception. Otherwise, there would be an ambiguity in the statute of what happens under that circumstance. And you can see that someone in the legislature obviously thought about that and said, well, we're not going to mandate it. We'll give them the option, but that's the answer. It's necessary to avoid a statutory ambiguity. There's no further questions. I know 417 left.
But you're, and you addressed this in response to Justice Coriel's question, but I didn't really follow the answer. So you're saying that the absent that permission to pay 100%, that they would be required by the statute to do the 80% of whatever was billed?
Yeah.
And what's the answer for the real world scenario where the insurance company would just voluntarily choose to pay more than they otherwise are obligated to under the statute?
The answer is that, and we articulated in our brief, that there are any number of economic reasons one could justify that. For example, let's say you have 5 competing chiropractic groups, but one is the lowest cost provider. And you want to encourage that. But that provider is significantly lower cost. So you'll pay them at 100% because that puts competitive pressures on the others. We've articulated in a footnote some other economic reasons, but ultimately that is, I think, Your Honor, a judgment of the legislature. Otherwise, if you read and agree with revival, may becomes must, it becomes shall. And you now have an exception where you must pay not only 100%, but you have the option, according to hands-on, of paying 119% in this case. And there's no justification to conclude that the Florida legislature believed that it was not only okay to eliminate the copay paradigm upon which the statute is based and which led to lower premiums, but that you're going to pay medical providers 100% or more than 100%.
I mean, I don't think the issue is whether it's a legislative judgment or not. The issue is, what does the statute mean? I mean, I don't think anybody's denying that.
I agree with that.
You know what I'm saying? So that's kind of begging the question.
And we believe the statute's plain on its face and it means what we said, but in answer to Curiel's question about what's the rationale behind this, that's the rationale. There's an economic rationale. One of the interesting things I did learn in this process, I didn't know much about the copay issue, was study after study, and we cited the federal government study, shows that, although it's counterintuitive, copays actually improve medical care and reduce medical costs. And when you think about it, it makes sense, but they actually did a study. We cite that in our footnote. And so one of the implications of the read that Revival argues for is to eliminate copays, which long-term will increase premiums and decrease benefits.
It doesn't always decrease that option because there's always the schedule. There's always a cap. And you would never have to pay more than 80% of that schedule, correct? So there is always going to be a cap on what the insurance companies have to pay under the statute.
Not in the context of this case, because if a medical provider bill is less than the cap, you're paying 100%. And the medical provider bill, by definition, should be a reasonable charge. That was the quote that I read you from the lower court case. And so that what that means is you are eliminating a copay, so the insured gets 100%, diminishing the insured's benefits faster, and you've changed the statutory paradigm, and long-term, the judgment of the legislature in the past has been that that will cause increased premiums, and we know it will diminish the benefits. I understand the argument, but I don't think that's consistent with legislative history. And the study that we cite from the federal government, the Medicare study, shows that long-term it decreases benefits and increases premiums. Now, in an individual case, I agree with you. In an individual case, it may have something different, but in a macro sense, because legislatures deal with macro issues, they can't deal with individual issues generally. In a macro sense, it has those deleterious effects. Thank you very much.
Thanks, and we'll add 2 minutes to rebuttal since we
Thank you.
get into your time. Thanks.
Good morning. May it please the court. My name is Chad Barr, and I, along with Larry Kopelman and Allison Laterman, have the privilege of representing the respondent in this case, Rebuttal Chiropractic. I've been handling appeals since I got my bar card nearly 15 years ago, and I just want to say this morning that it's a privilege to appear before this court, and I thank you for giving us the time on this issue that's so very important to both of us. We're here today asking this court to enforce the provisions of the PIP statute that, as this court stated in MRI Associates, govern in plain and unambiguous terms the payment of PIP benefits pursuant to the permissive schedule found in subsection.
Counsel, I'm sorry,
581.
I have a question, and I hate
Good
to
morning.
chop you off at the legs there, as you just started. But respond directly to Allstate's statement that they say is central to this case, and it's really a question. And they said, where in the statute does it say that the insurance company must pay 100% of the billed amount under the circumstances present here?
Well, I think the easy answer is that it doesn't. It doesn't say you must, and that's never been our position. And I think that's where the true divergence in the progression of this case has been. Is Allstate's position has been from the get-go, we don't have to pay 100%. You're right, you don't have to pay 100%, but you have two options. The two options are 80% of 200% of Medicare, which the legislature put in place to eliminate all this litigation regarding the reasonableness of expenses and charges and payments and all that stuff. The other option is 100% of the charge submitted, which is found in the last sentence of 5A5. So our position is not that Allstate has to pay 80%, has to pay 100% of the charge, but the court is enforcing the lowest possible option against Allstate, which is to pay the amount of the charge submitted. So in the instance where we've got a charge where, and just to give you an example in real time, you've got a service that the Medicare fee rate is $150, 80% of that is $120. Provider submits a charge for $100. Allstate has two options. They can either pay 80% of 200% of Medicare, or they can pay the amount of the charge submitted, which is $100. So we've never once taken the position. We've done this twice now. We've argued this at the 11th Circuit. This is the second level of appeal with this issue. We've never once argued that it's a mandatory, you have to pay 100% of the charge. That's never been our position. It's based on that permissive option found in 5A5.
But your argument necessarily is a requirement, because the statute uses the word may, as they suggest, instead of must or shall. So why isn't your argument that it's a mandatory requirement when the statute does not require that?
Well, the statute requires one of two things, and that's really our position. And so the court.
But counsel, it seems like this is all predicated on your argument that Allstate has stipulated that its insurance policy states that the schedule is the exclusive method of calculating reimbursement. Now, you assert that.
Correct.
And where does that come from? I mean, I've got it. I've got the stipulation here. What paragraph is that in?
Well, I believe it's a combination of their policy and what they actually chose to do, which was to reimburse pursuant to the fee schedule.
You said
So
they
if it's-
stipulated.
If it's a misstatement, then I apologize, but I don't think
But you
that-
can't cite me to a place in the stipulation that says that.
Not as I stand here.
Okay.
Not as I stand here today, Your Honor.
Well, but then it seems like your whole argument is assuming that once you go with the schedule, you're off under that rubric entirely. And if you don't accept the schedule amount, you're under the provision the May provision, which leaves out the rest of the statute, in which this court recognized in our MRI opinion. We've got these two different ways, two different overall ways of going about this, and one of those you're just kind of leaving out. It seems to me as part of the premise for what you're arguing. What are we missing?
I think what you're missing is the question that Judge Munoz and Judge Coriel are asking is, at the end of the day, why is the legislature including a provision in the statute that gives the insurance company the option to pay more than what it's required to pay? And so in this instance, if we take Allstate's argument literally, what Allstate is saying is that they have the option to pay 80% of a reasonable charge, or they can pay 100% of the charge. Why would the legislature do that? We have to interpret.
Well, and I understand the argument, and I understand that provision raises questions. But your answer to the questions it raises is to transform a may to a shall. Okay? Now, when we've got a question about how we're going to interpret a statute, and it's uncertain exactly what this was meant to accomplish, it seems like one of the last things we ought to do is change a may to a shall to resolve that. Why am I wrong about that?
I'm having a hard time understanding why there's two options. So we start from the beginning, which is.
But what you're saying, at the end of the day, what you're saying is once they've elected the schedule, not exclusively, but I guess you've conceded that they haven't done that exclusively. But once they're off under the schedule, they've invoked the schedule, or they have said that they will use the schedule to limit their charges. Then, if we get one of these billings that's below the schedule amounts, authorized schedule amounts, then they're constrained by this provision that says they may pay something. And so the may becomes a shall. I don't understand how I can understand your position as anything other than turning that may into a shall.
And again, I want to start with the policy, and I don't agree that if there's not a stipulation, I still don't agree that the policy doesn't exclusively elect the fee schedule because of what it says on, even just look at page 8 of their brief, that the portions that they highlighted indicates that they will pay pursuant to the 80% of the following schedule of maximum charges, which tracks 5A1. So they're saying we are going to, the methodology for determining the amount Allstate will pay for such expenses shall be limited to 80% of the following schedule of maximum charges. So they're telling the insured, we are going to pay pursuant to the schedule of maximum charges.
Well, but counsel, they say if they go on in paragraph 10 of the stipulation, the portion of the policy that's quoted there, if a provider submits a charge for an amount less than the amount determined by the fee schedule and so on, we will pay 80% of the charge that was submitted. It's right there in the King's English.
Sure, and they're rewriting 5A5, and that's what they can't do. They cannot take a provision of the statute which provides for the minimum amount of benefits and reduce that. So they can't say, we acknowledge that we're going to pay pursuant to 5A1, and this court in MRI said if you're going to pay pursuant to 5A1, you have to play by the rules found in 5A2 through 5, and then turn around in your policy and say we're going to take 5A5 and we're going to parse out the section that doesn't benefit us so that we can pay less than what the statute requires us to pay. So that is what they're doing in their policy.
But again, counsel, that seems to ignore what it says right there at the beginning of the statute, where it says under required benefits in subsection 1 of 627.736, it says right there that required benefits will include payments as follows: 80% of all reasonable medical expenses. That's That's right there. That's foundational. We've said that.
And what else is foundational? The rules of statutory interpretation. So we have this general concept that we're going to pay that we're going to require 80% of reasonable expenses. Then we have the more specific provisions in the PIP statute would say, if you're going to not only, I think more importantly, the policy language is what actually happened, which is they have chosen to pay pursuant to the fee schedule. So that's more important to this analysis than what the policy says. But once you choose to pay pursuant to
I don't understand that.
If
you say they've got their policy. Their policy determines what they've chosen,
which is 5A1. Okay, and so then we've got the general overarching, not overarching, but the general expense mandate or reasonable expense mandate. Then we've got the more specific 5A1 provision. And the 5A1 provision has been held time and time again that it satisfies that reasonable expense mandate. And then within that specific provision, you have rules that the insurance company has to follow. Again, if we take their interpretation of 5A5, what they're saying is that you can pay, your insurance company are allowed to pay 100% of a charge instead of 80%.
Counsel, it just seems like that line of argument is running up against what we said in MRI. Because basically what you're assuming is once they have elected the schedule, that it is effectively an exclusive election, and then they can't use these other provisions of the statute, including this overarching provision. And I just don't see how that can be squared with what we said in MRI.
Well, the question becomes, what then is the purpose of 5A5? What then is the purpose of 5A5? When we look at that with 3 sentences, the first 2 govern how you elect the fee schedule.
But how do we reconcile with what you're saying with it? You haven't asked us to recede from what we determined in MRI from our reasoning there.
No, because it doesn't address this issue. MRI Associates addresses how you incorporate the fee schedule into your policy and whether or not there are 2 exclusive methods, but it doesn't say that if you choose one route that you can avoid the rules that are set forth in that provision. So if you elect 5A1, you still have to play by the rules. The provider has to play by the rules, and so does the insurance company. There are requirements that in 5A2 through 5 that the provider has to follow as well.
So then if I can let me try and tell me if I'm picking up what you're putting down here. So then the may is not a conversion. Your argument is it's not really a may masquerading as a must. It is instead a may that is referential to the previous choice, which is if you choose to use this option, then you may pay this. It's not that we're saying you must pay this. The reference here is to the choice you made by electing to proceed with this cap schedule. Have I now sort of stated your position?
Yes.
Okay. I may or may not agree with that, but if that is the statement of your position, if that statement is accurate, then it seems to answer that. I think I'm hearing is your answer. We're not rewriting that may as a must. That may refers to the choice you made a minute ago, insurer, by selecting the schedule.
Correct.
So since you have selected the schedule, then you may pay this.
Right.
Okay.
Yes.
Or you may not.
Or you may not.
Or you may not, in which case you pay 80% of 200% of Medicare.
I still am struggling with understanding how your argument is not a variation of the forbidden hybrid method argument that we rejected in MRI. Because basically you're saying you got to be under one or the other. I mean, I think that's integral. I mean, that's foundational to your argument. And I can't see, I mean, that was at the core of what we were citing there. We said no. There's not a prohibition on having a hybrid method. That's fine, because these methods aren't exclusive.
This isn't a hybrid method, though. What Allstate did in this case is not a hybrid model. It's not a hybrid method. It's not a hybrid method of reimbursement. What they did was they said, we are going to exclusively rely on 5A1. We're going to disregard the last sentence of 5A5, and we're going to pay whatever we want to pay.
No, they didn't.
Yeah, yes, that's exactly what they did.
They said basically if I understand it correctly, and I think the Second District explains this pretty well in their recent opinion. basically what they're saying is, okay, we're going to accept the billed amount as a reasonable amount. We're not going to fight over it. We're not going to argue about whether what you billed is a reason, if it's below what would be allowed under the schedule. We're not going to argue about whether that is a reasonable amount. We're going to accept that as reasonable, and then we're going to follow the mandate of the statute to reimburse you 80% of the reasonable charge which you have submitted, which we accept as a reasonable charge, what you billed. And it boggles my mind that a provider that bills a certain amount is in any position to claim that that's not a reasonable charge.
Well, the issue is not the reasonable charge. The issue is the reasonable reimbursement. And so what we're dealing with in this case is Allstate saying they didn't do a reasonableness analysis. They didn't look at this and go, we're going to pay pursuant to what's reasonable. They said, we're going to pay pursuant to the fee schedule, which satisfies
but
it.
I think what he's saying is that they're basically waiving any ability to challenge the reasonable. They're sort of taking, I mean, first of all, the provider can't really fee schedule amount, or I can pay the billed amount, as if someone's going to sit there and decide voluntarily to pay more. I mean, aren't we really kind of left? It seems like we're not really getting ourselves out of this conundrum with the at least intuitively kind of odd real world effect of the way it's being run.
I appreciate the question. There's a distinction in how we look at this. The first one is Allstate saying we need this option to pay more in case we wanted these things that they're describing, which they don't need statutory permission to do. We believe the legislature included 5A5 to accomplish what Allstate may want to accomplish with that, which is to encourage medical providers to charge less and to provide prompts with payment of medical expenses. But the second side of that is, and I apologize, I lost my train of thought. But could you just repeat your question for me more? I'm sorry.
I mean, you're saying that you're saying that one of the weaknesses of their argument is why would anyone ever, if it's a may, why would you ever, choose to pay the billed amount when you could do 80% of the billed amount? And what I'm saying is, why would anyone ever, if you're saying that the other thing is you have the option of paying 80% of the schedule or the billed amount, why would you ever choose option one in that scenario?
I appreciate you repeating your question. The whole point of 5A5 is, and we can go back to the very first decision on this issue, the Irizarry decision, and we can look at it and say, all right, that laid the groundwork for what 5A1 required, which is to pay expenses pursuant to the fee schedule. They didn't have the opportunity to address this lesser charge issue that was done for the first time by the 4th ECA. And so the legislature, our position is the legislature included 5A5 to prevent, as a fail-safe for insurance companies, to not have to pay more than what a provider charges in the event that a provider charges less. So our position is that 5A5 is actually a protection. It's not a it's not the same as what Allstate's arguing in their argument. We're saying that 5A5 is a protection for the insurance company, so they don't have to pay more. It gives them an option to pay less, and so that's wholly distinguishable from what they're arguing, which is they have to be given the opportunity or the option to pay more if they want to, which just doesn't make any sense. No insurance company is in the business of paying more. In the legislature, it's superfluous.
Well,
There's no reason to add that in there because they can do it.
They do answer that argument. They do answer that argument, though, don't they? I mean, maybe you should respond to their explanation, which is, indeed, we have economically rational reasons to pay more sometimes, and the legislature meant to give us that option because we may want to reward certain providers in a market, or I guess my question to you is, are they right about the policy freedom that they've been given? And if that policy freedom has been extended to them by the legislature, what business do we have unsettling it?
Again, I don't use the word absurd in my normal parlance, and I appreciate that it's a part of the case law that discusses statutory interpretation, but it's an absurd result for the legislature to have included or to interpret this provision as the legislature including an option for the insurance company to pay more. And if we go back to the 80%, what they're saying is we have the option of paying 80% of reasonable expenses or the amount of the charge submitted, which is more than that. So there's no rational interpretation that leads to that result.
But I guess I'm asking you to respond to the one that they've in fact proffered. The rational explanation is we may choose sometimes to pay more because it might be in our tactical business interest to do so under certain circumstances. Do you have an answer to that?
They don't need permission to do that. They don't need the legislature's permission to do that. They can always pay more. The case law is clear. An insurance company can always pay more. If they truly wanted that option, they would have included it in their policy, but they didn't. They actually tried to do the opposite. So it kind of cuts exactly against what their argument is that that we want to have that option. So no, it wasn't meant for that. It was meant to protect the insurance companies from having to pay a lesser charge at 80% of 200%.
But if we're going to start kind of talking about what we think is rational and everything, I mean, at the end of the day, you submitted a bill for X amount. By definition, you think it's reasonable. We know that the sort of Uber principle here is that the legislature wants there to be reimbursement at 80% of reasonable. So why would the legislature want a result where you're saying that 80% of what you essentially stipulate is a reasonable amount isn't enough?
Well, I think the rational explanation is that the legislature didn't want a medical provider who submits a charge that's less than 80% of 200% of Medicare from being reimbursed automatically at that rate. They wanted to give the insurance companies the option of either paying 80% of 200% of Medicare or less.
Okay. Your time, you can have 30 seconds to finish up.
Yes, thank you.
That was an interesting exchange. I'd like to start with Your Honor's question. Nowhere does the statute say pay 100%. And in fact, the argument he just made in answer to Chief Justice's question was pay 100%, or in this case 119%. That's Allstate's options. That's what hands-on holds. The statute just doesn't say that. Second point, the stipulation. The stipulation doesn't just simply have the language about 80% of the amounts billed less. The stipulation does much more than that, very close to the hybrid in the State Farm case. If you look at page 2 of the stipulation, paragraph 7, after it says, quote, the methodology for determining the amount we will pay for such expenses shall, pursuant to the fee schedule limitations under section 627.7365A1 of the Florida statutes, or any other limitations established by section 627.736, and the overarching limitation is the 80% amount. So this policy is very analogous to the State Farm policy, and it has any other limitations, which is the overarching 80% limitation in addition to the fee schedule, plus the paragraph 10 quote, which Justice Kennedy pointed out, says what it says. You can't run away from it, and it's foundational to the revival argument. Third, when you strip away the arguments, they're all predicated upon a binary choice. And this court has rejected that in MRI Associates. And the reason this court rejected it is because if you don't reject that, then you have to do what the federal district court did. You have to rewrite the PIP statute in 4 material respects. You have to eliminate the 80% payment limitation. You have to mandate 100% payment or more of bills. In this case, under his interpretation that he just argued to this court, Allstate's choice was to pay 100% of a medical provider's reasonable medical bills or 119.2%. 119.2%. Where in the statute or its legislative history is there any suggestion that a reasonable medical bill, which they do not contest that this was a reasonable medical bill, should be paid at 100% or 119.2%? That's their statutory interpretation. 3, the word must has to be transformed, the word may has to be transformed into must. There's just no other manner of looking at it. We've given you our interpretation that without that language, there'd be an ambiguity in the statute of what happens when someone submits a bill of a certain type, less than the fee schedule. But it doesn't make any sense what he's arguing, because nowhere does the statute suggest that the legislature made a legislative policy decision to injure insureds, to eliminate copays, and to long-term increase the premiums for the citizens who are insured in this state. And because of that, we would ask that the court answer the certified question or the modified certified question in the affirmative and revert this to the 11th Circuit so it can properly apply the law of Florida. And finally, this is my third time.
Sorry, sir, to interrupt you. If you could please wrap up.
Yes, I am. This is my third time in this court. It's a privilege each time. About every 7 years, I'm privileged to come down here. So thank you. I'm not sure what to make of it each time. I think it's the last, but thank you very much for allowing me the privilege. It's always a great pleasure. So thank you.
Thank you.
Thank you. We're adjourned for today.
All rise.